Hi, my name is Joe DiBartolomeo. I'm an Oregon workers' compensation lawyer. I have offices in Astoria, Oregon, and Hillsboro, Oregon. I represent injured workers. And in today's video, I'm going to talk about what your rights are as an employee when you file an on-the-job injury claim. The title of this video is a question of basically asking whether you can be fired if you suffer an on-the-job injury and file a claim. The short answer is no, you cannot for that reason, and we'll get into greater detail on that. Now, let me make a disclaimer. I am not an employee rights lawyer. I don't handle employment cases. However, I come across this issue quite a bit when representing injured workers, and the question comes up. That's why I'm making the video, because these are maybe a few things that are good to have knowledge on while you're going through the process, so you can understand what your rights are, but also what your responsibilities are, and understand what the employer is looking at when this happens. And when I say this happening, I mean an on-the-job injury claim. So let's get started, and we'll hopefully get through this and provide you with some good information. So when we talk about reinstatement and reemployment, that language comes from a statute that guarantees the right of an injured worker to get their job back after they suffered an on-the-job injury. So reinstatement means that if you suffer an on-the-job injury and your claim is accepted as being job-related, and that's a big deal, and you get better, you're fortunate enough to make a good recovery so that you can go back to the job that you were working, that job is available to you. Your employer has to give you your job back. Now, there are other requirements. There may be issues about how many employees your employer actually has on their books. There may be a minimum number, but generally speaking, under this statute, if your employer is subject to this provision, you get your job back if you're able to go back physically, your doctor releases you. Now, you may have to make a demand for it in writing. And again, there are a lot of different requirements involved, but the general rule is you get your job back. And that's true even if somebody has replaced you to do the job while you're off work and recovering from your injury. There also may be some special rules involved when you're a member of a collective bargaining agreement, you're a union member. So look into that. You may want to talk to your union rep when you're looking at reinstatement. Now, reemployment is different. Reemployment is a right that you have under state law if you are injured on the job and you make a recovery, but not enough of a recovery that allows you to go back to the job that you were performing when you were injured. When that happens, again, if your employer is subject to this statute, your employer has to provide you with suitable and available work. You have to ask for it, but your employer has to provide that to you. Now, suitable means that you can actually physically perform the work, and available means that it's available. The job has to exist. And sometimes that can be an issue when you make a claim for reemployment. And what I mean by that is there may be an issue about whether or not there's actually an available position. Now, the other part of suitable has to deal with the hours and the wage that you're paid for the job. It has to be comparable to the job that you are working. For example, if you were making $25 an hour, working in, I don't know, Warrenton, Oregon, and you were injured, and your employer, maybe they're a big company and they have another location in Ontario, Oregon, they can't offer you 20 hours in Ontario, Oregon, making $10 an hour. It has to be comparable. And there are a whole set of rules that talk about what suitable and available is. So that's what we mean when we talk about reemployment. It's another job that you were not working and is offered to you if available. Just by way of example, we have seen situations where one that just popped into my head is a situation where our client was working for a local employer and they were pretty badly injured and they were not able to go back to what they were doing. And this employer actually promoted our client and gave them more of a supervisory role in the company, which I thought was laudable. That was a pretty good thing to see from an employer. They valued this employee. And so he ended up getting a promotion. So that's one example of a reemployment right being exercised and followed through with by an employer. Now, these are statutory rights that you have under Oregon law. Again, it has to be a disability that resulted from an on-the-job injury. So if you file a claim and the claim is denied, or if part of the claim is accepted, but part is denied, and the part that's denied is what's disabling you, you don't enjoy these rights. These are rights that are conditioned upon the disability being related to an on-the-job injury. Now, I have other videos that talk about claims being only partially accepted and what you can do about it. New or omitted medical condition claims are the topics of those videos, and you can check those out. I also have an Oregon workers' compensation guide. I actually have quite a few. And if you're watching this video on my YouTube site, I will put a link to some of the offers down below. If you're looking at this on my website, there's a free information link above. And I have a few different workers' compensation consumer booklets that you can download. They're ebooks. They don't cost anything. There's no obligation. So the last part of this video, I want to talk about the employment relationship generally and give you some examples of where an employer may try to get around the requirements to either reinstate an injured worker or reemploy an injured worker. Oregon is an at-will employment state. And what that means is that the employer can hire or fire any employee for any reason or no reason at all. Now, there are a lot of exceptions to that rule, and I just covered a few of them with the right of reinstatement and the right of reemployment. But what an at-will employment relationship is a relationship between an employer and an employee. And the only term of that relationship generally is that for the work that you perform as an employee, the employer pays you. Now, there are other employment relationships that are recognized in Oregon, and one example would be what we call a for-cause employment relationship. And if there is an agreement or evidence of an agreement that you serve your employer, and they can only let you go or dismiss you for just cause or a cause, that's a different kind of employment relationship. Oregon recognizes at-will employment, and that means that you may be working for your employer and they may just not feel like you're a good fit, and they may let you go for that reason. Or you may be chronically late. Even though that's a reason or a cause, they can let you go for that. So even though you have these protections, if you're an injured worker who suffers a disability because of their on-the-job injury and the claim has been accepted, your employer may still exercise its right as an at-will employer and let you go. Because those protections that I talked about are only for disabilities that occur. Now, before I get into this at-will employment, another protection that you have is that you cannot be terminated, or any term of your employment cannot be affected if you invoke or file a workers' comp claim. And when I say invoke, I mean invoke the system or procedures of the workers' comp statute, or actually file a claim. Or maybe you're a witness to a coworker's injury and you testify at a hearing. The employer cannot fire or affect any term of your employment, like cutting hours or wages, because you did one of those things. You are protected. Now, at-will employment still gives the employer the option of letting you go for some other reason. So let me give you an example. somebody is working at a lumber mill and maybe they drive an old truck to and from work every day and it's a 20-minute drive. And that old truck tends to burn some oil. And they've been there for a couple years. And every day or a couple times a week, they notice that they're low on oil. And they get a coffee cup and they go into the oil room and they take a little bit of oil and dump it in the engine and off they go. Nobody cares. It's like in an office environment, maybe you take some pens home from work. Nobody cares. But then they get hurt on the job and they're disabled and they're doing light duty. And they go into the oil room and they take a little bit of oil and they put it in their truck. Next thing you know, they are terminated for theft. Now, there's nothing inappropriate about the employer enforcing that rule, although there could be an issue about whether that was the actual reason for the termination or if it's really because we're dealing with an injured worker who just happens to have a disability. The lesson here is that if you're injured on the job and your employer is maybe hostile to you filing the on-the-job injury claim, the workers' comp claim, they may be looking for a reason to push you out the door. I say it all the time. So if you are dealing with that kind of an employer, keep your nose clean, assume that you have to file or follow every rule, every procedure, and that it's just like you just started working for that employer. Don't assume that you can do things the way they were. So you have to be careful. People are watching you. This doesn't happen all the time, but it happens quite a bit. So just to review, you are an at-will employee for the most part in Oregon. Depending upon whether your employer has to follow the rules, you may have a right to be reemployed at a job that you can physically handle if it's available, or if you make a full recovery, you get your job back, again, assuming your employer is subject to the statute. But keep in mind that you're probably, at least in most cases, an at-will employee. So the employer may be looking for other opportunities to lay you off or terminate your employment. And one last review is that these rules may be different if you're a member of a collective bargaining agreement. So that's the answer to the question. Can I get fired if I suffer an on-the-job injury? Yes, but that's what most lawyers are going to always say. If you have questions, contact us. Again, we don't generally handle employment claims, but we know lawyers who do, and we often work side by side with them when representing our clients. So if we can't help you, we will put you in touch with somebody that can, or at least give you some resources. Check out the website. I'll leave a link below if you have other questions. I hope this video was helpful. Thank you for watching. Take care.